a series that we're entitling Harvesting Legal Knowledge. I'm serving as your host. My name is Jeff Missling. I'm the North Dakota Farm Bureau Executive Vice President and CEO. And this is kind of a joint collaboration between NDFB and Ohnstad Twichell Law Firm. With us today, we have Casey Drege and Marshall McCullough. Thank you, gentlemen, for being back here again. Yeah, just going through and having a conversation right now about what are some things that you might not want to do or some common mistakes that are made, I guess, legally and things to avoid. So if you have any thoughts on that topic, we'd sure like to discuss them.
Well, Jeff, I would say the number one mistake that we see would be the failure to do anything, just to sit back and do nothing when it comes to both your business practice and your estate plan is probably the biggest mistake we see. For an example, if you do not have a last will and testament, the state of North Dakota has one for you. And we'll say if you're maybe a single individual with 4 children, one of whom farms, 3 of whom do not farm, and you pass away without a will, you may have just put the farming heir out of business. North Dakota would provide that 25% to each of the 3 or each of the 4 heirs. So the one farming heir would now have to rent 75% of the land, 75% of the machinery equipment, 75% of the bin space, and also only receive 25% of the cash to fund the future operation. So the decision to do nothing, as the song says, is still a decision. We just think it's the wrong one.
Casey, thoughts?
Do nothing is wrong, but also do something using AI is also wrong. So we're fine if you want to do that to, write a recipe for your breakfast in the morning, how to make the best eggs, use AI. If you're looking to, plan your estate or draft a complicated document, AI is not there right now. We've toyed around with it and kind of looked at it. It will want to give you an answer that makes you happy. So unfortunately, the law doesn't work that way. So it will misstate the law. And we have seen documents come in from clients that are missing key aspects in certain documents. So AI is something we're seeing a lot. Be very, very cautious if you're going to use it.
Marshall?
I guess the next one I kind of have on my list is you have to be careful how you title or treat different planning ideas. Some planning ideas are irrevocable, and irrevocable means exactly that. We can't change it in the future. In one of the series, we'll be talking about real estate. One way to transfer real estate is to do a life estate to your children, typically. I had a client that gave their land to their 4 daughters, one of who died prematurely. Her 25% interest in the land went to her son, who married an individual conveniently referred to as Floozy 9 months after the daughter had died. And needless to say, my clients were very upset that the son-in-law, ex-son-in-law, and Floozy now had access to that property. We were able to work with the gentleman and ultimately transfer that back to his children, the grandchildren of my client, but he did not have to do that if he did not choose to do so. So to do something that's irrevocable, you have to understand all the consequences before you sign it.
Other items, gentlemen? I don't know, Casey, do you have anything else on your list of?
Yes. Governing documents. We will cover these in another video, but these are basic documents that you need. We've seen some pretty big horror stories as far as either not having governing documents or having governing documents that didn't address what they needed to address. The reality is things are going to change. You're going to get married, you might get divorced, you might have children. You need to account for all of those things 10 years in the future, 20 years in the future. And governing documents are those things that will help you protect your assets and protect your family members.
The last one I would caution anyone watching the video is to double check or triple check beneficiary designations. Beneficiary designations or joint ownership of assets overrides most of the documents that will be talked about throughout the series. I have had clients that maybe have upwards of $200,000 in a checking account that they wanted their son or daughter to have signature authority, be able to write checks on that account, but they made it a joint account. And once one passed away, the other joint owner received the entire $200,000, which they decided they did not need to share with any of their siblings at that time. So it did cause an issue, but it was perfectly legal. A joint account goes to the joint owners. A beneficiary designation goes to those listed as beneficiary, and you need to double check those at all times.
Some really good advice for anybody out there listening. Thank you, gentlemen, for your helpful pointers here today, and we thank you for your time as well. Thank you for joining us, and if you want to check out more videos like this with kind of the correct way of going about doing things legally, please check out the more videos in the series that are to come in the future. So thank you.